So Genelle, I got a question that comes from our online users, and one of it goes like this. What is the divorce process in Wisconsin? So it's pretty general, but so in a general sense, what does that look like?
Sure. So in the state of Wisconsin, there is a 120-day wait period from the date of service of the petition and summons on the other party before you can actually enter a judgment of divorce in any court in the state. So you have to initiate the filing with, as I said, the petition and the summons. There's also another document that's going to be filed along with that called the confidential petition addendum. That includes all of your confidential personal information that will be sealed in the court file and not shared with the public. Also, you're going to be filing a financial disclosure statement which lists not only your income, expenses, assets, and liabilities, but also indicates whether or not there's any other pending litigation or bankruptcy petitions that might exist. From that point, you can either file jointly, where there would be no requirement for service of those items on the other party because they've already received that inherently in joining in the petition and signing that document. If you are petitioning without your spouse signing as a joint petitioner, they need to be served personally. You can effectuate service either through the sheriff's department or with your own personal process server. And sometimes, if the other party already knows that it's coming and is cooperative, they can even sign an admission of service to avoid any expense that might otherwise be incurred through that process. There is going to be approximately 3 to 4 weeks into the action something called a temporary order hearing. And at that hearing, initial issues of who's going to be living where, who's going to be paying what bills, and if there are children, we want to establish a temporary placement schedule and child support orders related to that. From there, you're going to have an initial period of negotiations, and if you can get everything wrapped up in writing, filed with the court in a settlement document, you can, at that 120-day mark, get a judgment entered through a stipulated final hearing. Obviously, if there are contested issues, that timeline may lengthen and third parties may become involved, such as a guardian ad litem, to assess the issues of custody and placement if they remain contested, or you may need appraisals or vocational assessments, other items like that, to firm up some of those contested issues before you could set a trial date.
Thank you for watching this video. Please like, subscribe, and share. Your interaction with our content is greatly appreciated. Visit sterlinglawyers.com to learn more about our firm and meet our attorneys.